Assalamualaikum and good day everyone. Today I will be presenting on job hiring discrimination, the Malaysian legal approach on equal employment opportunity. Before I begin, let me introduce myself. My name is Mohamad and Raihan bin Ishaq and my student ID is 2024276898. This presentation explores what hiring discrimination means, the type of discrimination that commonly happen in Malaysia, example from real case, the existing legal framework, weaknesses in enforcement, and potential improvement for a fairer hiring system. Let's start with introduction. What is hiring discrimination? Hiring discrimination refers to unfair treatment of job applicant based on characteristics that are not related to their skill or ability to do the job. These characteristics typically include gender, race, religion, age, disability, marital status, or even appearance. This occurs when employer bases their decision to hire or reject candidates on personal bias, stereotype, of preference rather than objective job requirement. For example, an employer rejecting a qualified candidate simply because of she wears job, or preferring a younger applicant even though the older one has more relevant experience. Next is why hiring discrimination is a problem. Hiring discrimination harm both individual and organization. When companies base on decision on bias rather than merit, they lose access to talent that could contribute significantly to their organization. For society, it's widen inequality because the opportunity are not distributed fairly. Discrimination also damages an organization's reputation, especially today when candidates share experience online. It also goes against the principle of meritocracy, which means people should advance based on ability, not a personal background. Let's move on to type of hiring discrimination in Malaysia. There are several common types of hiring discrimination observed in Malaysia. The first one is gender discrimination. This happens when men or women are preferred for a job without valid reason. For example, hiring only male supervisor for administrative work, assuming men are more decisive. And the second one is age discrimination. Many jobs as specified age limit like 18 to 30-year-old. This automatically excludes experienced older workers even though her age are nothing to do with performance in clerical or customer service role. The third one is racial and religious discrimination. Certain Malaysian industry still show preference for specific race. For example, starting with China's preference or company rejecting candidates who wear hijab for customer service job. Next is disability discrimination. This occurs when an employer rejects applicants with disability even though reasonable accommodation could allow them to perform effectively. Next, appearance-based discrimination. Some ads demand height, skin tone, attractive that has no link to the job function. And last, marital or pregnancy discrimination. Women are sometimes rejected because employers assume they will be less committed or unavailable due to family obligation.
Diskriminasi dan peluang mendapat pekerjaan kepada golongan orang kelainan upaya OKU tidak berubah di negara ini. Pengasas Persatuan Kesejahteraan Autisma AIDA, Patrice Leong berkongsi bahawa dasar kerajaan menetapkan 1% peluang pekerjaan kepada OKU yang tidak dipenuhi sejak 30 tahun pengenalannya jelas satu isyarat keterbukaan yang lemah dalam memberi peluang sama rata ke atas golongan berkenaan.
Dasar 1% pengambilan kerja OKU ini bukannya satu yang baru. Telah lebih 30 tahun kita mempunyai dasar ini tetapi tidak pernah kita capai.
Now I will share the Malaysian legal framework. In Malaysia, we do not have any single one law that directly prohibit hiring discrimination. Instead, we rely on several laws that offer directly on a partial protection. The first one is Federal Constitution, Article 8. Article 8 states that all persons are equal before the law and should not be discriminated against based on religion, race, distance, gender, or place of birth. However, this protection primarily applies to government and public sector employment. For the private sector, Article 8 does not directly enforce hiring equality. but it doesn't set the principle that discrimination is unacceptable. The second one is Employment Act 1955. The Employment Act provides minimum labor standard but does not directly regulate hiring. However, it protects women from being dismissed due to pregnancy and ensure basic right after employment begins. The third one is Industrial Relation 1967. This act allows employees to file a complaint or unfair labor practices while it mainly applies after employment. Discriminatory action that lead to unfair dismissal can be brought to the industrial court. And the last one is Person with Disability Act 2008. This act promotes equal opportunities and encourages employers to provide reasonable accommodation to PWDs. However, this act does not impose penalty for discrimination, making enforcement weak. Now, I will share some real Malaysian case. To understand the issue better, here are a real example from Malaysia. The first case, hijab ban in hospitality. Some hotel previously rejected women wearing hijab for front desk position, claiming it affects their international image. The public backlash eventually pushed many companies to revise this policy. And the second case is pregnancy discrimination. Many women report being rejected after disclosing pregnancy. While no law directly forbids this at the hiring stage, it is clearly violation principle of gender equality. And the last case is racial preference in job advertisement. It is common to find as specifying Chinese preferred or Malay only, especially on online job portal. This shows that racial bias is still normalized in certain industries. Despite having a several law, there are major gaps. The first one is no single anti-discrimination law regulating hiring practices. The second one is private sector hiring in largely unregulated. And next, job seekers have limited legal remedies. They cannot easily sue for discrimination. And the fourth one is enforcement is weak because many protections only apply after employment begins. And the last one, no official guideline for fair hiring in Malaysia. To move toward fairness and equal opportunity, organizations should adopt the following HR best practice. The first one is blunt recruitment. Remove personal details such as age, race, gender, and photo from CV to reduce bias. The second one is structured interview. Use standardized questions so all candidates are evaluated fairly. And this third one is clear job requirement. Ensure advertisement include only skill or qualification that are relevant to the job. And next is anti-discrimination policy. Company should include a written policy prohibiting discrimination in hiring and during employment. Next is unconscious bias training. Train HR personnel and interview panel to recognize their own hidden biases. And the last one is provide accommodation. For PWD facilities, technology tools, or flexible schedule can help PWD perform effectively. This small effort can significantly increase equal access to employment. In conclusion, hiring discrimination remains a significant issue in Malaysia, especially in the private sector. Although some laws provide a partial protection, Malaysia still lacks a comprehensive anti-discrimination law to protect job seekers. Therefore, organizations must take a proactive step to ensure equal employment opportunities while Malaysia continues working toward a stronger legal framework that supports fairness and inclusivity in hiring. That concludes my presentation. Before I end, here are the references that support the information and evidence I shared today. Thank you for your time and attention. I hope this presentation has given a clearer understanding of hiring discrimination and Malaysian legal approach to equal employment opportunities.